You were having certain sessions in the auditorium also. You attended that session there. Now you have come over here. The whole idea of having different sessions is that you get an opportunity to have a one-to-one contact with these honorable Chief Justices who have come from different parts of the world. It's very unfortunate in this particular session that we do not have very many people who know very much of English. One judge has not been able to make it for the session for whatever reason. We have these three people here who are going to deliver their speeches in their own languages, and we have the translators. I have one translation with me. I will be reading out that translation. We will be taking questions also from you in case you are prepared with the questions. But overall, it's going to be ultimately you and me. So let's understand that what is law enforceability. Do we understand? It is working, moving, walking towards international law that is enforceable. That is, we want to make an international body. It appears to be a very idealistic thing right now. But in years to come, we feel that there will be a time when all the countries will unite and will form a government, will form laws, will have a judicial body where laws will be made, laws will be implemented, and they will be enforceable. Enforceable means either I follow the law, and if I do not follow the law, it is punishable. Even in the present times, we have international laws, but we have noticed over the years that those laws, if broken, nobody is punished. In the previous session, we were discussing that we as adults, we have done whatever we could. And it's now at this juncture of our lives, we realize that we have not done it all that well. We probably have not given a thought to it, or we have not been able to do our best. So the next possible thing is that we transfer that responsibility to you and expect you to live peacefully and expect you to work in a way that we have enforceable world laws. That is the idea of this whole session. In this session, therefore, I expect all of us to be actively participating, trying to understand the whole spirit of the idea, and thus go back enlightened. You may not like it all that much right now. The whole system is to work on your subconscious. Day in and day out in City Montessori School, you are listening to the
Eğer benim gibi hakimlik veya savcılık yapmak istiyorlarsa, önce Adalet Bakanlığı'nın açtığı yazılı ve sözlü sınavlarda başarılı olmalıdır. Sonra 2 yıllık staj süresi sonunda ülkenin ihtiyacı olan yerlerine atanmaktadır. 2 yıllık sürenin bir kısmında Adliye ve Yargıtay'ın çeşitli birimlerinde görev almaktadırlar. Stajın kalan bölümünde ise Adalet Akademisi'nde yapmaktadırlar. Ülkem adına sevindirici olan önemli bir konu da hukuk eğitimi en çok kadınların tercih etmesidir. Son yıllarda Türkiye'de kadın hakim, savcı ve avukat sayısı hızla yükselmiş ve bu mesleklerde kadınların çok başarılı oldukları gözlenmiştir. Konuşmam kısa oldu. Beni dinlediğiniz için teşekkür ediyorum.
Thank you. Thank you. I'll read out the translation for you. Although this translation also does not appear to be very much English, still. She began with saluting you all as valuable participants. Legal rights and justice is concept of a set. Society is the necessary condition for peace and maintain law and order in the development of life. If the legal order is not there, there is anarchy in the society and there is chaos. How the layout of law is provided? The only answer is studied law. In the world of law education, how important that is, conference participating in the great value legal professionals, the number of excesses also understood. That is, in the world of law education, it is very important to have conferences of this kind, and with this, when we have excess number of participation, that is, when we have so many people participating, we are expecting an outcome in the direction that is desired. At this point, you own my country, which is in Turkey. Law training I would like to mention in my country, Turkey, what kind of law training is provided. Studied law in recent years, Turkey is the most preferred section. Very many students in Turkey have started opting for studying law. Especially foreign language is being educated to young people, because of which the demand of this education has increased. Young generation of lawyers are, a few of them are multilingual also, and they are going abroad for careers, and they are equipped to grow. That is, English language is also educated and given importance in Turkey, because of which youngsters are able to go outside also. Law faculties are usually 5-year training. That is, in Turkey also, law is for 5 years. After studying graduate programs, other than the other courses, the lawyer's profession is, you can become a lawyer if you choose to be after 1 year's period. Then they have to enter an examination, and if they are successful, then profession can start. If you want to be a judge like me and give judgments like her, that is, if you want to be a judge like her in Turkey and want to give the prosecution, if you want, before Justice Ministry started, there has to be, the ministry has begun with oral and written examination, and you have to be successful in that. That is, once you have completed your 5 years training in law, you have to wait for a year. After that year, you have to appear for an examination, and if you want to be a judge who is definitely above the lawyer, you have to appear for a written and oral examination, and if you are successful in that, then you become a judge. Then you have 2 years internship during that time of the country, and wherever you are required to be appointed, you are sent there. These 2-year period of part of those courthouses and the Supreme Court there are several varieties of courts in Turkey. Like in our own country, we have smaller courthouses and we also have the Supreme Court. There are judicial academies also where internship is conducted, and you can be a part of that. a very nice part about law education in my country, that is Turkey, is that there are many women who prefer this occupation. And in recent years, Turkey women judge, the prosecutor and lawyer, the number of these people has risen rapidly, and women are very successful lawyers in Turkey. Thank you for your attention. Thank you very much. At this juncture, I would request Madam Justice Claudia Losek from Poland to please deliver her speech.
Good afternoon, everyone. I am a judge from Poland. It's far, far away, but I am a second time here because I love India so much. I was last time on the conference, and I came again, and I hope to be in the next future also. Maybe it will be possible. What I prepared for today for you, you probably have a general information about how to be a judge in your country, how to start that career. And yesterday I thought about very sad story. I'm thinking about a very sad story which happened in Turkey, in Ankara. Another terrorist attack, another very sadness things. Many people are died. This is also the rule for us judges. I'm a criminal judge. I'm never working with a terrorist trial yet, but everything is before me. I'm waiting for that. I have to be prepared for that. And I have to also to share with you, with my experience, with my small knowledge about it, how judges have to prepare themselves to dealing with the terrorist trial. I have some information from the memorandum which was prepared by United Europe in Haga. There are about some good practices which judges have prepared in the work. Are you writing about it? Sorry, I'm writing. I not remember this on my own for now, but I think it will be most correct. Human society nowadays is conformed with terrorism phenomena. Judges will be expected follow to international proceedings with terrorists. It is very difficult to give a good definition about terrorism and terrorist. Terrorist is not an ordinary defendant, like we know, and he has to be treated with special proceedings and special punishment. Is a big difference between ordinary rape or murder and terrorists because of victim. In terrorism attack should be many victims. Terrorist attack affecting huge number of innocent citizens. That attack is usually unexpected, start to be reason of social frightening. It is commonly understood as strong and independent judiciary is guarantor of independence, impartiality, and fairness. This is only right way for public confidence in the legitimacy of judicial institution and effective deterrent to terrorism and minimize the risk of violation of fundamental human rights. Recognizing that each legal system around the world is unique and each actual practice is tied to states' individual regulation, national laws, history and culture. Of course, very important is to set a good practices as a main factors of the judiciary in handling counter-terrorism. Those good practices also assist the judges to more effectively adjudicate cases and are guarantor of the fair trial rights of the accused on the protection of victims and witnesses. I never, like I said before, I never to adjudicate terrorism yet, my own personal experience as judge dealing with criminal cases is about to adjudicate other national security offenses, as well as used to some of good practices for my recognizing cases also, just to be assured that my trial is independent, fair, and impartial. Those good practices I mentioned below have to be also a significant component in judicial decision-making process with sentencing convicted terrorism. So the first main practice, which is important in my working life, is necessity for specially trained judges. That specially trained judge can be responsible for all phases of the case, up to the final resolution in the form of sentence. That judge have already handled serious cases and demonstrate the appropriate judicial temperament. The specialized training should be continuous through the time when judge is working, sitting on the bench. We need guarantee that case is conducted with a rule of law framework with a full respect for fundamental freedoms and the human rights of the accused person. Even the accused person is a terrorist. The second good practice for judges is counteraction of the lies trial. The negative impact of the lies is shared by all the participants in the judicial process. The accused, who is often detained and pending trial, the victims and their family, who have been harmed by the offenses committed against them, and the community that demands justice, safety, and protection. Terrorist trial judge, in his judicial decision-making process, is responsible for safeguarding both the rights of the accused and the victims. Therefore, in all cases, the trial judge should seek to avoid delays, continuances, and extended recesses, be proactive in ensuring punctuality, the strict observance of scheduled court hours, and the effective use of working time to identify and resolve issues that may result in delays. Terrorist trial judge should also permit full and proper examination and cross-examination of witnesses, require such examination to be conducted fairly and within reasonable time constraints. The judge has not to permit unreasonable repetition or permit counsel to pursue clearly relevant or improper lines of inquiry. Judge should has authority to manage the progress of the case. Third good practice, this is a key element to ensuring that the parties are prepared to proceeds to fair conclusion without unnecessary delays and interruption. The trial commences as scheduled, judicial trial management. So this is necessary for set a firm trial date, ensuring continuity and predictability, outline the rules of court procedure, review the scheduling of witnesses to ensure that there is continuity, and review the nature of their testimony to avoid unnecessary duplication of determining of some evidence, if uncontested, might be presented with mutual agreements such as through stipulation. Also be receptive to using technology as I be available in managing the trial and presentation of evidence. As a part of judicial decision-making process, sentencing convicted terrorists, trial judge should be decisive, consistent, requiring punctuality, like I said before, minimizing trial interruptions, and developing knowledge of the applicable law. The trial judge in cases involving terrorism is obligated to use special measures to protect victims and witnesses. Judges should have a flexible approach to address the unique demands or needs related to victims and witnesses as they arise. Such protective measures might include the redaction of a victim's or witness's name an address from written statements provided to the defense as a part of pre-trial disclosure, imposing a ban on the publication of the name and address of the witnesses or victim in connection with the proceedings, or in the alternative closing the courtrooms to the public for portion of the hearings of trial proceedings. The trial court may allow witness anonymity when permitted by law, of course, in exceptional circumstances. One of successful way of that measures are use a pseudonym, for example, witness A, concealing the physical appearance for witness, like wig, glasses, fake facial hair, facial distortion, voice distortion, expunging the public record of trial, permitting video link testimony, allowing witness to testify via secure video link and not be present at courtroom, permitting disclosure limitation, limiting the time when the prosecutor or defense can have access to identify of witnesses of other party, and limiting as much as possible the circulation and subsequent potential for compromise of sensitive material. During recognizing the terrorist case, judge must also supporting the rights of the accused to a fair trial with adequate legal representation, such as the right to a fair hearing without undue delay, the right to a public hearing in the pronouncement of a judge with limited exceptions, presumption of innocence, freedom from compulsory self-incrimination, the right to be informed properly and in detail of accusation, adequate time and facilities to prepare a defense, the right to legal assistance, the right to examine witnesses, the right to an interpreter, the right to appeal the conviction and sentence, freedom from ex post facto laws. The nature of terrorism-related offences and the impact they can have on a nation, there is a very real potential for many to call for abrogation of the rights of the accused persons. This highlights in the particular need for judges to ensure the rights of the accused person, often through effective legal representation of all accused persons in terrorism cases. Support the development of legal framework of guidelines for the use and protection of evidence from intelligence sources, methods, are also such a good practice for good methods for judges. One of the basic principles of a fair hearing is that the individual charged with a criminal offense be informed of the evidence that supports the allegation that have been formally lodged. A significant exception to the requirement to disclose relevant material in its original form is when the information evolved is from intelligent sources and methods. The issue arises frequently in cases involving terrorism charges. Violence and acts of intimidation have accompanied terrorism cases in many countries. It provides obligation for necessary security also for judges, like extending security measures for judges and their families outside of the courthouse, court personnel, victims and witnesses. It is essential to ensure a fair and effective criminal justice system that is free from intimidation, retaliation, and obstruction of justice. Judiciary should develop rules and procedures for media coverage of public judicial proceedings with good practices to control the conduct of the proceedings. As a general rule, timely access to accurate information of court proceedings increases transparency and public confidence in the fairness of the justice system, but court might be prohibit the use of any audio pickup, recording, broadcast, or video. That is all about that practice. Of course, it's very hard to say how their practice really helps in judicial work, because they helps, of course. But when somebody is a judge and have deal with very important, very very hard things like terrorist trial, this is not only emotion. This is only obligatory to be a good person for everybody, to be to respect the law of everybody. In his book Civilization and its Contents, Sigmund Freud asserts that men are not gentle, friendly creatures wishing for love, who simply defend themselves if they are attacked, but that a powerful measure of desire for aggression has to be reckoned as part of their instinctual endowment. This was Sigmund Freud, the very famous writer, of course, and very famous researcher. Despite of that, as long we are a human, we should try to live in peace, security, tranquility, and reject all forms of violence, fanaticism, racial segregation, and terrorism that threaten peace and stability in this society. This is motto for us
dentro de un ambiente no solo sostenido, sino también sostenible, y además en un ambiente equilibrado que le permita un desarrollo no solo económico y social, sino sobre todo dentro de un ambiente familiar equilibrado, especialmente en aquellos casos en los que los progenitores tienen nacionalidad distinta del país de residencia del menor, también es distinto de aquel en que se reclama la retención ilegal internacional.
In accordance with the Convention of the Rights of the Children, the defense of their dignity with the right to live in an environment not only sustained and sustainable, but also in a balanced environment that allows you to not only economic and social development, but above all, within a balanced family environment, especially in those cases in which the parents have a different nationality and country of residence of the children other than in which claims are the international legal withholding.
Es innegable que los estados modernamente, con independencia de su sistema de gobierno y tipo de organización han dejado de ser entes autosuficientes, y dentro de un contexto cada vez más globalizado y regido por el desarrollo de la ciencia y la tecnología, han desarrollado una serie de mecanismos de integración cada vez más eficaces, pero al mismo tiempo el proceso de integración dejó de ser un asunto que concierne en exclusividad a los estados en sus relaciones diplomáticas y económicas, entre otras, sino que las mismas se han ido extendiendo a las relaciones existentes entre sus propios ciudadanos y estos con los ciudadanos de otros estados.
It is undeniable that states in modern times, regardless of their systems of government and the type of organization that have structured, cease to be self-sufficient and within a context entitles each more globalized and governed by the development of science and technology, have developed a series of increasingly effective integration mechanisms. But at the same time, the integration process was no longer a matter which concerns exclusively to the states in their diplomatic or economic relations among others, as they have been spreading existing relationship between its own citizens and with the citizens of other states.
Dentro de este contexto, los ordenamientos jurídicos también han sufrido cambios tanto a nivel interno como externo. Esto es desde la perspectiva del ordenamiento jurídico nacional íntimamente relacionado con el ordenamiento jurídico internacional.
Within this context, the legal systems have also suffered changes both internally and externally, that is, from the perspective of the national legal system closely related to the international legal orders.
En la actualidad, los estados se han visto obligados por necesidad de integración a tener que ceder soberanía en diferentes aspectos, desde luego en temas muy puntuales, como es el caso de la cesión de soberanía normativa, en la que sobre determinadas materias han celebrado o se han adherido a suscribir una serie de tratados internacionales, los mismos que una vez suscritos y ratificados pasan a formar parte del ordenamiento jurídico nacional y por consiguiente ser aplicados por los tribunales de justicia de cada estado que los haya sufrido y o ratificado, y en otros casos la suscripción y ratificación de los tratados versa sobre la cesión de soberanía jurisdiccional en la que los tribunales internacionales tienen que emitir decisiones jurisdiccionales en la solución de conflictos cuando los mismos son puestos en conocimiento de acuerdo a los procedimientos preestablecidos.
Currently, the states has been forced by necessity of integration to have to cede sovereignty in different aspects. Certainly in very specific issues, as it is case of the transfer of regulatory sovereignty, that on certain matters held or had acceded to sign a series of international treaties, the same as one signed and ratified, they become a part of national legal system and therefore must be applied by the courts of justice to each state that them has signed. In the other cases, the signing and ratification of the treaties it concerns and transfer of the jurisdictional sovereignty, in which international tribunals have to issue judicial decision in the resolution of conflicts when they are brought to their knowledge according to pre-established procedures.
Dentro de este contexto, muchas veces el legislador nacional, por decisiones eminentemente políticas, a través de los mecanismos legales internos, emite normas jurídicas que en algunos casos colisionan con el derecho internacional, específicamente con determinados tratados internacionales. Y al producirse la controversia, los jueces tienen que efectuar no solo un control de constitucionalidad, sino además un control de convencionalidad, a efecto de hacer prevalecer las normas jurídicas vinculantes emanadas de los tratados internacionales, así como de la jurisprudencia que dictan los tribunales internacionales cuando vinculen a los estados que hayan suscrito y ratificado determinados tratados, como es el caso de la Corte Interamericana de Derechos Humanos para el caso peruano de suscripción y ratificación de la Convención Americana de Derechos Humanos, entre otros.
Within this context, many times the national legislator, by essentially political decisions through this internal legal mechanism, emits legal norms which in some cases collide with international law, specifically with certain international treaties, and to produce controversy, judges have an obligation to not only control of constitutionality, but in addition a control of conventionality, effect of making to prevail under binding legal norms of international treaties, as well as the jurisprudence dictating the international tribunals when associating states which have signed and ratified certain treaties, and it is the case of the Inter-American Court of Human Rights, the Peruvian case that signed and ratified the American Convention of Human Rights, among others.
En este orden de ideas nos encontramos ante la Convención sobre los Aspectos Civiles de la Sustracción Internacional de Menores del 25 de octubre de 1980 dentro del marco de la Conferencia de La Haya sobre Derecho Internacional Privado.
In this vein, we are faced with the Convention of the Aspects of Civilians in the Subtraction of Minor in October 25, 1980, within the framework of the Conference in The Hague on a Private International Law,
cuya convención ha sido suscrita y ratificada y puesta en vigencia por el Estado peruano mediante resolución legislativa 27302 del 26 de junio del año 2000 y el Decreto Supremo 023-2001 RE del 1 de agosto del 2001, se aprueba y ratifica la adhesión del Perú a la referida convención, por lo que a través de resolución ministerial 22006-2002, Promudéis, publicada en el Diario Oficial del Peruano de fecha 31 de marzo del año 2002, se designa la Gerencia de Promoción de la Niñez y la Adolescencia como el órgano en la representación del Ministerio de Promoción de la Mujer y Desarrollo Humano, que realizará las funciones de autoridad central encargada del cumplimiento de las obligaciones que le impone al Estado peruano la Convención sobre los Aspectos Civiles del Secuestro Internacional de Menores.
The international law, whose convention has been signed, ratified and put into force by the Peruvian state through Legislative Resolution 27302, 26 June of year 2000, and Supreme Decree number 023/2001 RE from August 1st of 2001, it approves and ratifies the accession of Peru to the aforementioned convention. So through resolution ministerial of 2006-2002 Promulgate, established in the official journal El Peruano of 31st March 2002, refers to the management of promotion of childhood and adolescence as the body that, on behalf of the Ministry of Promotion of Women and Human Development, who will perform the function of a central authority responsible for compliance with the obligation imposed by the Peruvian state. The Convention of the Civil Aspects of the Kidnapping International Minority.
La designación de la Gerencia de Promoción de la Niñez y la Adolescencia como autoridad central se debió a que dentro de sus diversas funciones está la de dirigir, coordinar y supervisar la política nacional en materia de niñez y adolescencia, en concordancia con las normas jurídicas del Estado peruano y de los compromisos internacionales asumidos por el Estado.
The appointment of the management of promotion of childhood and adolescence as central authority was due to its various functions, its direct coordinate and supervise the national policy on children and adolescents in accordance with the legal standards of the Peruvian state and the international commitments assumed by the state.
En el caso del Estado peruano, es preciso advertir que ha suscrito y ratificado la Convención sobre los Derechos del Niño, en la que se establece que las decisiones que tomen los tribunales se debe considerar primordial atender al principio del interés superior del niño y la obligación de los Estados parte de luchar contra los traslados ilícitos de los niños al extranjero y de su retención ilegal o ilegítima. Y al mismo tiempo el Perú, acorde con la Convención sobre los Derechos del Niño, promulgó y ha puesto en vigencia el Código de los Niños y Adolescentes, habiendo consagrado en su artículo 9 del título preliminar el principio del interés superior del niño, cuyo principio concuerda con lo normado por el numeral 1 del artículo 3 de la Convención sobre los Derechos del Niño, pero también ha consagrado una norma jurídica de vital importancia en la solución de conflictos relativos a niños y adolescentes, como es el caso de lo prescrito por el artículo 10 del título preliminar del Código de los Niños y Adolescentes, al prescribir que en los casos sujetos a resolución judicial o administrativa en la que están involucrados niños o adolescentes, serán tratados como problemas humanos.
In the case of Peruvian state, it is necessary to warn that has signed and ratified the Convention of the Rights of the Children, 1989, which provides the decision taken by the courts. It should be considered primary care to the principle of the best interest of a child, and the obligation of states to part of the fight against the illicit transfer of children abroad and their illicit retention. At the same time, Peru, in keeping with the Convention of the Rights of the Child, enacted and put in force the Code of Children to prescribe that in the case subject to judicial or administrative decision which are involving children or adolescents will be treated as human problems.
En buena cuenta, desde la perspectiva del ordenamiento jurídico peruano acorde con el derecho internacional, ha consagrado el principio del interés superior del niño y tratar los temas en los que están involucrados niños y adolescentes como un problema humano. En tal sentido, resulta válido considerar, desde mi particular punto de vista, que la Convención sobre los aspectos civiles de la sustracción internacional de menores debe ser interpretada desde una perspectiva amplia cuando se trata de la retención ilegal, ya que cuando es ilegal debe ponderarse adecuadamente el interés superior del niño y ello, el caso concreto, será tratado como un problema humano.
Guragan, from the perspective of Peruvian legal system, in accordance to the international law, it has enshrined the people. The concern is valid for concern from my particular point of view that the Convention of the Civil Aspects of International Child Abduction of Minors must be interpreted from the wide perspective when it comes to the unlawful retainer, because even though it is illegal, but the best interest of the children should be properly assessed, and in each case it be treated as a human problem.
Lo sostenido precedentemente parte de la reflexión efectuada al inciso A del artículo 1 de la referida Convención sobre los aspectos civiles de la sustracción internacional de menores, en cuanto a que los Estados deben garantizar la restitución inmediata de los menores trasladados o retenidos de manera ilegítima en cualquier Estado contratante.
For previous part of reflection to subparagraph A, word Article 1 of the aforementioned Convention on the Civil Aspects of the International Child Abduction is the state should ensure the immediate return of a children transferred or retained in any contracting state unlawfully.
La inquietud parte del hecho de que existen casos y casos, pero en todos ellos se parte de la obligatoriedad de que los estados contratantes garanticen la restitución inmediata. Pero ¿qué pasa cuando los niños tienen como padres a sujetos de diversa nacionalidad y el nivel de conflicto familiar lleva a uno de ellos a tomar la decisión acertada o inapropiada, lícita o ilícita, de trasladar al niño y o retenerlo en un país distinto al de uno de los progenitores y distinto al de residencia habitual del niño?
The concern is based on the fact that the cases to cases, but in all of them are based on the requirement and that contracting states to ensure immediate return. But what happens when children have as parents to subjects of different nationality, and the level of family conflict takes one of them to make the decision successful or improper, legal or illegal. Move the children in a country other than the one the parents and other than the habitual residence of a children.
La calificación de la licitud y ilicitud dependerá en cada caso concreto en aras del interés superior del niño. Es natural y comprensible que el progenitor directamente afectado inicie el procedimiento establecido en la ya referida convención a efecto de lograr la restitución del menor al lugar de su residencia habitual, pero al mismo tiempo es comprensible que ante el requerimiento de autoridad central, el Estado requerido administrativa y judicialmente adopte una defensa obligatoria del progenitor afectado y exija a los tribunales de justicia que en aras de la Convención sobre los aspectos civiles de la sustracción internacional de menores, en un procedimiento rápido y sencillo, ordenen la restitución del menor trasladado o retenido ilegítimamente con miras a restituirlo al lugar de su residencia habitual, esto es, en el estado requiriente, pero es aquí donde surgen algunas interrogantes.
The qualification of the legality or illegality will depend on each case in particular for the sake of the interest of children. It is natural and understandable that the parent directly affected start the procedure established in the already referred convention, effect the achieving the return of the child to the place of their habitual residence. But at the same time, it is understandable that at the request of the central authority, the requested state, administrative and judiciary adopt a mandatory defense of the affected parent and request the Court of Justice for the sake of the Convention on the civil aspects of international and abduction of minors in a quick and simple procedure ordering the return of the transferred or unlawfully retained with a view to return it to their habitual places, residences. That is in the requesting state, but it is here where some questions arise.
Unas preguntas serían: ¿la tutela jurisdiccional efectiva debe verse solo desde la perspectiva del derecho del progenitor del Estado requiriente o también del progenitor del Estado requerido? ¿Es posible que el progenitor afectado en su Estado obtenga una decisión judicial pronta requiriendo que se haga efectiva la Convención sobre los aspectos civiles de la sustracción internacional de menores? ¿El derecho de defensa del progenitor del Estado requerido estará debidamente protegido desde la perspectiva del derecho a aprobar la excepción contenida en su artículo 12 de la Convención relativa a la integración del menor a su nuevo ambiente frente al requerimiento inmediato de restitución? ¿O también podrá demostrar en tiempo oportuno la improcedencia de la restitución por los supuestos contenidos en el artículo 13 de la Convención sobre los aspectos civiles de la sustracción internacional de menores?
The questions are: effective judicial protection should see from the perspective of the right of the parent of a requesting state or also the progenitor of the requested state. The second one is that the affected parent in your state get a prompt judicial decision requiring to make the convention on the civil aspects of the international children abduction effective if it's possible. Third, the right of defense of the progenitor of the requested state will be properly protected from the perspective of the right to prove the exception contained in Article 12 of the Convention concerning the integration of the minor to his new environment facing the immediate requirement of restitution. The fourth one, the last one, the last of the question, be evident timely the inadmissibly of the refund of the assumptions contained in Article 13 of the Convention on the civil aspects of international abduction of children?
Es indudable que las respuestas girarán en torno a un aspecto eminentemente positivista y o principista, pero en cualquiera de los casos la temporalidad tendrá un rol preponderante en la toma de decisiones por los órganos jurisdiccionales y en el derecho de defensa de ambos progenitores, sobre todo del requerido por la retención ilegal del menor a quien se le exige la restitución inmediata.
There is no doubt that the responses will rotate around a look eminently positive of Marxist or Leninist, but in either case, the temporality will have predominant role in decision by the courts and the rights of defense by both parents, especially than required by the illegal withholding of the child who demands the immediate restitution.
Como podemos advertir, finalmente, es una pugna entre progenitores en las que el menor está en el centro de la disputa, con el alto riesgo de ver afectado su propio interés, en algunos casos, no en todos, por la inmediatez con la que deben actuar los estados para la restitución de la retención ilegal internacional de menores. Por tanto, corresponde a nosotros los jueces dar las respuestas más apropiadas frente a las preguntas planteadas, pero siempre desde la perspectiva del interés superior del niño y viendo el caso como un problema humano dentro del marco de la legislación internacional y, por supuesto, también de las normas jurídicas nacionales.
As we can notice, finally, it is a struggle between the parents in which the minor is in the center of the dispute with the high risk of adversely affected their interest. In some cases, not at all, by the immediacy with which must act states for the restitution of the international legal retention of minors. Therefore, correspondents to us judges give the most appropriate answer, face the questions posed, but always from the perspective of the best interest of the children, and seeing the case as a problem human within the framework of international law and, of course, also of the national legislation.
Espero haber motivado algunas inquietudes en torno al tema, aun cuando aparentemente nos encontremos ante situaciones sencillas de resolver. Gracias.
I hope to have been motivated some concerns on the issue, even we are seemingly simple to resolve situations. Thank you very much.
Thank you. So, this is the end of the presentations that have been made by Honorable Justices. And in this, I'll just briefly brief you, very briefly brief you regarding the things that we have gone through, the things that we have learnt in the whole process. There is one thing which is unanimous among all the countries. In the previous session, we had an Honorable Justice from Paraguay. He said the same thing, and here in this also we have the same things coming up. That is, whenever there is contradiction between domestic and international law, the judges will have to finalize what exactly needs to be followed. But then it is an international treaty, an international convention that has been attended, a treaty that has been signed, a tribunal where people have gone and represented their country. If something has been signed over there, that is at the international level, that is the law that prevails in every country. And in every country, domestic law has to be made in such a way that it conforms to the laws at the international level. We came to know how one has to prepare himself to be able to be a judge in Turkey. We also learned in the process how one has to prepare himself to give judgment on international rules, international laws, to solve international issues. For that, we understand there is a need to educate even the judges for international laws, because in different countries where there are law organizations, law institutions, domestic law is taught. Not as much as as much emphasis is given on international law. So there is a need to have organizations or institutions where international law is given a lot more importance, that we start understanding and then implementing international laws. We learned from Madam Justice in Poland how judges have to prepare themselves to give judgment. There are certain good practices that have to be followed. That is, they have to adjudicate cases on national security. There are times when they have to specially train themselves in order to have a correct temperament to conduct judgments according to the rule of law. there is a question on the personal safety of the judges and their families outside the courtroom. So there is a need to provide safety to the judges outside the courtroom as well. The judge has to be able to see through lies that are given by the terrorists. The judges should be able to be consistent. They should be flexible, and they should have, she says, a positive attitude towards special circumstances. The trial should provide anonymity, and technology is to be used to maintain anonymity. She ended with the idea which was presented by Sigmund Freud, saying that human beings have a very strong desire for aggression, and that desire for aggression needs to be subsided. Now, students, if you have any questions, it is in one case that we will be able to take the questions from Justice Dr. Jaime Antonio, because we have interpreter only for Spanish. So you will be able to refer your questions only to Mr. Justice, whereas for Turkish and for Polish, we do not have the interpreters. So I request your questions to be marked only for Justice Dr. Jaime Antonio. Madam, can we put forward questions to you as well?
I can try.
Fine. So you may refer your questions to Madam from Poland as well. Yes.
Good evening to all the excellencies here. Good evening to all the excellencies here. My question is that as we are learning in this parallel session that the topic is enforceability of international law. We all in the world, every man follows different faith. Many people have different religions, and they belong to different sects and countries. So, ma'am, if they follow different faiths, if they have different beliefs, how can we form an international law that comprises all those beliefs and all those religious sentiments, so that nobody gets hurt and justice is provided with just and fast procedure?
Su pregunta es que, como el doctor Andy tiene una idea para formar un gobierno mundial y para formar una institución judicial para promover la paz y para hacer todo el mundo. Pero nosotros tenemos una...
Maybe during the time I will try to respond for a short time. I think that it's very important to remember about universal, general truth, which are sometimes writing on the agreement between one country and another, one state and another. Sometimes we have some international law which are starting from some General Assembly like United Nations, like United Europe's organ bodies. Like I heard today, the domestic law have to respect international law. International law how to respect the religions, the difference, the other sides of personality of all citizens of the world. Of course, it's not perfect. It's not perfect. Every time it's growing, changing, because our tradition, our habitants, something like that. But we are the people. We try to be perfect in this way also. So I think that listen to domestic law through the international law, through the international agreement. This is a good way to going for the respecting law for everybody. This is my response.
Cuando el mundo se ve más global, más cerca de todos, nos damos cuenta que las diferentes naciones, los distintos pueblos, distintas sociedades profesan un culto, una religión diferente. Entonces surge la necesidad de establecer un parámetro que es el de la tolerancia. Por ahí debemos partir.
As we know that we all have our individual religion sentiments that you are saying, for that we need to have a list of tolerance, like there should be some checklist sort of thing, that should be the highest point of tolerance for any religious sentiments. And from that, if we have that kind of a segment of tolerance, and if we can subjugate them into the tolerance, I think we will be able to achieve the religious sentiments that we have, the mean religious sentiments that we have, to overcome them and to achieve the global peace through the means of the World Parliament. Thank you.
Sí, complementarlo. Sí. Perdón. Perdón. Ellos se complementan dentro del derecho, tanto en el ordenamiento nacional como derecho fundamental a la libertad de credo, libertad de religión, y esto se puede plasmar como también hay tratados internacionales de respeto a las creencias religiosas.
And as in the national constitution, there should be the respect to the every respective religions. The same way, I believe that respect to the every religious sentiments and every respect to every religion should be there in the International Court of Justice and to form the World Parliament.
I'm Shubham from Kanpur Road campus. Good evening, honorable justices. My question is that League of Nations failed due to the domination of some countries. Don't you think the UN is facing the same situation, having 5 permanent members as more powerful because of veto pass?
I'm not sure I've good understand you. You ask about how United
Nations is facing same problems as League of Nations was failed, as it was dominated by some powerful countries, and UN is dominated by 5 countries that has veto powers.
Yes. I think that United Nations have a main role. Played a main role in that phenomena. This is very difficult. It's very difficult to compare every different phases of politician, to compare every religion. Like we know, Baha'i religion is also representative in United Nations. Why? Because the Baha'i religion is a universal. It doesn't matter what we feel about our God. It's important that we respect each other. So I think that United Nations have to go in this way. If I could understand your questions, I think that United Nations have many things to do for us. course, it's better distribute this part, but I would like not talk about it too much. You know why? Because I'm a judge. I'm not a politician. So this is not my subject which I have to comment. And there is a reason why I have a response like that and not other. So United Nations, I respect its work, but this is not my job, so sorry.
Es una pregunta muy interesante, pero hay que entender algo. El poder de veto se estableció dentro de un contexto, en un momento histórico. Ese momento histórico ha cambiado y obviamente hoy es como una especie de monopolio dentro de determinados países que tienen este privilegio. Allí, por ejemplo, la democratización no se ha dado. ¿Por qué? Porque se sigue rigiendo bajo un principio que en algún momento debe cambiar, que es el del poder. Han habido casos donde inclusive el Consejo de Seguridad de Naciones Unidas dijo no ante una decisión, pero alguien con mucho más poder rebasó todo ello y hizo lo contrario a la decisión. Es decir, el veto muchas veces se utiliza básicamente de acuerdo a determinados intereses y no de una perspectiva más democrática a ese nivel.
The initial ideas to create the Security Council and to have the veto powers amongst the important nations that you've said, that was your question, right? The veto power of the important nations. Now see, we'll have to understand certain things, like those are the formation which were done on the basis of the formation of United Nations and after the Second World War. So that was a historic point of view. And at the point of time, that was a historic necessity to form a world United Nations so that they can control every nation if there's any problem. Now, regarding those things and keeping in mind those things, historical things and the problems which occurred during the Second World War, the damages, the ravages, whatever things have happened, but those were the initial points that, keeping in view of those points, the Security Council and the veto power to whom it should be given, it was formed. But later on what happened, with the time, the situations have changed. Because when they had the initial powers to control the entire world, they had a different scenario. But nowadays, those power has become very powerful, and the democratic system, or the nature of democratic being, is no more there in the system. So with the time it has developed and the powerful countries has become more powerful, but for not distributing the veto power.
Sí, es posible que se pueda distribuir todas estas decisiones, pero obviamente depende mucho de las políticas que pueda adoptar la Asamblea General para cambiar este sistema que actualmente está vigente. Todo es posible, pero depende de decisiones políticas a ese nivel.
It is possible to distribute the power, or distribute the veto power amongst the other nation, which was the last part of your question. But at that highest level of political solutions is required, because it is not possible without the political solution it can come. If there is any high level thought and practice of political thoughts at that particular level, it is possible. Technically it is possible to distribute the veto powers amongst the other nation of the country so that they can also join in taking some decision worldwide. Thank you. In addition to that.
But every now and then we talk about equality, but sir, there is no such thing in UN as 5 countries are dominating the whole thing, and nothing can be passed without their suggestions or their approval. And sir, for example, demarcation of seas. Sir, talking about America, sir, it can access to 20 or 30 nautical miles, and India only to 10 nautical miles. So it is done by UN. Sir, what like this, sir? It's inequality then.
No, I'll just explain the question. He is adding the question that we talk about equality. We talk about equality, but that's not.
It has already been said that without political intervention, whatever rulings of UN are.
My name is Riya. I am from CMS RDSO campus, and good evening, Honorable Justice. And my question to you is that nearly the whole world is influenced by corruption, even the government. Then how can the government ensure that international law will not be corrupt?
It's a very hard question. How international law have not corrupt? Maybe because there are decisions of not only one person. Maybe because the decision of globally big assembly from our country. Of course, I think when we look at history, we have plenty of samples that one thing is good, another thing is bad. We never find a good solution, the perfect solution like the God. We try to be honest. We try to fight against corruption. And the international bodies have a special security from, I don't know how to say, the people who are working for that special bodies, they are selected. They have some exams. They have perfectly opinions. And they try to working with other people like that. And we have to believe them. But we are, like I said, we are a creature. We don't know sometimes if we're going in the good way or not. But we have to, here on the earth, we have to have some responsibility bodies. If we have to think that some states, some separately country may be corrupt, probably the 3 countries or 4 countries together may prohibit corruption. I think it's going on that way. And of course, we have to use the law, we have to do the rules, but like the rules can be changed also. So this is a general rules, general tradition to use everything what is perfect for us. So that is my opinion.
Thank you, ma'am.
Good evening, ma'am. My name is Shruti Agarwal. I'm from Chowk branch. My question is that although child labor international law was passed for Child Labor Act, but law was not enforced properly. Still children, they are working in mines, factories under the age of 14. What steps can be taken to enforce the law properly?
Yes, this is a big problem. Of course, if all penalty code in all states we have punishment for traffic humans, for other things like that. We judges, if you ask me, we can do only one thing. Maybe this is not only, maybe this is a huge thing. We have to respect our rules, our code, and if somebody prepare for us accusation for that people who is responsibility for that procedure, like you described me, we have to do all what we have to do the best to be a good judge and give a good judgment. But this is a global problem, of course. This is problem of poverty. This is problem of political gain. Of course, it's very hard to fight with them, but we have to. We have to. But I think it's good to have a own place to do. So I am a judge. I have my work. I have to do everything what I have to do my best to find with that. If you will, probably, I don't know, engineer, or if you will somebody else, not judge, you can do all. You can try to resolve that problem. How you will know about it. So everybody should treat like the hearts is talking about it. So.
Thank you, ma'am.
The child, I think he was in class 8. He said, everybody's talking about child labor, then nobody's talking about poverty. Once you eradicate poverty, child labor will come to an end. The child who's poor is given a choice whether if you want money, you have to work. The child starts working. That's how child labor starts.
So these are all the problems correlated.
Definitely, all correlated. Questions are there.
My question is, with changing time, laws will have to be altered. If one has been punished now for violating a law, and this law is made invalid in future, how will justice be provided to him?
Should I explain, ma'am? Good answer. Okay. When I
She says today there is one law, Law A, and because of that I have